We did send out, Dory, will you talk a little bit for the larger group as to our efforts to reach out to people to provide input?
So we availed ourselves of some very robust infrastructure that the Bar Association has in place. With Sarah and staff's help here at the bar, they pushed messaging in the form of banners across the website, specific targeted email outreach, newsletter entries, to solicit and invite input both from WISBA members and the public generally. It spoke to the opportunity to attend in person and telephonically, and also to participate in the webcast live. It looks as though we do have one question being posed now.
Please go ahead, if you think it's appropriate. We do need to maybe screen some questions, I'm not sure, being new to this.
So, Stephen Gonzalez, who I
yes,
believe would be Justice
that would be an
Stephen
appropriate question.
Gonzalez.
We will accept his question without reservation.
He indicates, I understood that in Flex, SCOTUS granted cert, vacated and remanded in light of Janus. Is there something pending now? And I know it was first brought to the attention of the work group by Mark Johnson that remand in light of Janus is now being considered again in Wisconsin. So
it's pending still. So we're just waiting to see what they do, and then waiting to see if it is then they re-seek cert in light of whatever they do. Mark, turn on your mic, please, and please join in. I need you to turn on your mic.
I actually don't have anything to say.
Oh, you didn't? Were you just mumbling over there?
Yeah. I've just reached my dotage, and I'm just talking to myself.
All right.
No. I think what Justice Gonzalez was asking is it's been remanded, but now the Eighth Circuit has got the case, right? Yeah.
that is my understanding, and I see Doug also nodding in the affirmative. So,
Doug, why don't you come and share what you'd like?
Yeah, there's not a great deal to add. It is pending. The remand is pending before the Eighth Circuit. It has been briefed in light of Janus as directed by the United States Supreme Court. And as Paula Littlewood mentioned, it's scheduled for oral argument on June 13th.
Eileen.
Two questions, and maybe Doug would have the answer. What position has the Wisconsin Bar Association taken about what should be done in light of Janus? And has the bar itself or any group convened something like this to discuss about what they should be doing or not doing?
It's North Dakota.
Ah, well, all right. Someplace flat. Sorry.
And
no offense to Wisconsin or North Dakota.
They've been aggressively, as I understand it, advocating the position that Keller is good law and Keller should be affirmed. There have been, I think, several amicus briefs filed, some from bar organizations. Julie Shankland, I think, is more familiar with that briefing than I. I don't think she's present today. But I think that the gist of it is an affirmance of Keller, possibly an affirmance on other grounds.
Thank you, Doug. Other questions from the work group? All right. Other questions? Justice Gonzalez, was that helpful to you? I guess he'll write us. One thing I was going to say is some of the questions that came up about what's happening in the voluntary bars or other places. I am blessed to have law clerks, and I think it would be very valuable information to find out, starting first with the National Center for State Courts to see if, in fact, they've done it. But I'm not sure to what degree, if at all, that they're focused on this. So I will find that out. And but if not, I'll try to have my staff do some reference and resource work that will be helpful to us, because I think part of it is just trying to sort it out. Yes, please, Andrea.
Thank you. I am not sure who would produce this, but I would be curious in terms of knowing where there is the distinction between the mandatory and professional services, where the diversity and inclusion programming has been directed, and what that has looked like.
I think based on the questions and the comments, it'll be partially figuring out what they're doing, but also sort of looking to what they actually do. More the function question that was asked about here at the bar, and we can talk with bar staff if that's something that would easily be produced, or if you want us to guess it on our own, like we'll be doing in these other states, trying to find source materials that would help us. And you could tell from some of the questions, it starts to become complicated in the sense that some courts like ours, have taken on certain subject matters through state commissions. We've taken on or advocated. Sometimes we were sort of out ahead, or there was a work group that came up with a recommendation that then resulted in a Supreme Court appointed board, and the sort of the marriage with the Bar Association. When I was bar president 22 years ago, hard to believe, we did not have Supreme Court appointed boards other than the Character and Fitness and Discipline Board, which to my knowledge had existed for a very long time. So it really changed the makeup and the dynamic of the bar by having those additional responsibilities added to. So there was always the regulatory side and there was the voluntary side, which were the sections and the committees. And there were many sections. There are more sections now. There were many committees. And that was just sort of how it functioned. And then we added this extra one, and then that started to sort of change the dynamic and like who's in charge. And we had many challenges even between the board appointees and the bar, and arguably from an extension of that, the Board of Governors. But who got to make what decisions about budget, about a variety of things, and who they answered to. And we saw it really come to a head a number of years ago with the Practice of Law Board, where there was really a very strong lines taken by the Practice of Law Board chair, and how that played out. And the court actually put a hold on the board, and then sort of regrouped and moved forward. And so I think besides always being sui generis, as Paul said, we also are probably still sui generis. Well, there probably won't be anyone that's exactly like us, because of just how we have chosen to do our business. But I think there are lessons to learn and to think about, and aspects. I know for the bar staff, access to justice and diversity and inclusiveness have always been very important, and that they felt that would fall on the regulatory side. There are people, of course, who do not think that those would fall on the regulatory side. And there are many, as we sort of heard, Nebraska seems like it's almost something that they've, part of it they've put on the regulatory side, but part of it they're not really, doesn't sound like they're doing too much in the access to justice area at all. So part of it will, I think, depending on what we do, will depend on how we define things, or how we characterize it. Now, Client Fund for Protection, I think that's CF, yeah, which the court imposes that amount, and it is required. Now, Nebraska had that as voluntary. Here, I would think that would clearly, or might be, we could decide, we could make a recommendation. But in my mind, at least at this point, it's regulatory. If you want to practice law in Washington, you have to pay that fund. You have to pay your dues, but you also have to pay that fund. It's collected separately. It goes into a dedicated account, and it's used in a certain way. And so I think as we're thinking about different aspects, we can look to some of these for other ideas, but we also are just going to get to do our own. I think Paula made a really good point also, in the sense that, both speakers made excellent points. I don't mean to qualify it or quantify it, but I thought one excellent point was we can do all this, and I think I personally think it's very important, which is why I agreed to chair, and why I, like you, am dedicating this time and thought to it. But whatever we do, depending on what the U.S. Supreme Court does, then that'll be what it is. So we might be close or we might be completely off base. So part of it is saying we want to be the masters of our own future, our destiny, to the extent, the controllers of our own destiny, to the extent we can be, recognizing that we are not the final word. And depending on what the final word is, there may be some like regrouping or some adjustments that would have to be made to the work we have done. But I think the work we're doing is really important and necessary for us to grapple with these challenging issues. And separate and apart from Janice and Fleck and Keller before that, I think it's important to relook at things. And so even if we weren't being, in essence, sort of feeling compelled to do something, I think it would be important work for us to do anyway. And I think we have the right people at the table and we have the right people present and in the audience and engaged that will help us as we move through. So those are just some of my reflections on where we are at this point and based on the presentations this morning. Mark.
Thank you. So the Texas case, McDonald versus Longley, the plaintiffs have moved for summary judgment in that case. And I'm reading there, which was filed less than a month ago, but they say the bar nonetheless uses compelled dues to fund expansive political and ideological activities such as lobbying, diversity initiatives, access to justice programs, pro bono initiatives, and more. So that's the issue that they're teeing up in these cases, the diversity and access to justice programs. So those, I think, eventually, when the U.S. Supreme Court gets it, that's going to be those will be the programs in the crosshairs one way or the other. I don't think the discipline and those things are going to go away, but that's and all these cases, the commonality throughout the country is taking pointing at the diversity, access to justice, pro bono programs.
Hunter.
So I'm starting to think more about procedurally where we are here, and I think it was really helpful, and I really appreciated both the in-person comments that we received today as well as the written comments that people took time to submit. I think that is extremely helpful. One of the things that, at least in my mind, might be helpful as we go forward would be just some sort of a collating and a reduction down to of the various models that exist out there. Maybe looking at, I don't think this would be a very big product, maybe a single-page summary of the different models that we've seen out there. For each one, for example, we could have the Washington model as it exists currently, and then we could have one on California as they've moved to. Virginia has been talked about as an example of one of the few states with two different bar associations out there. I think it would be interesting to look at that sort of Nebraska hybrid model, maybe what I would call a more clear voluntary bar association model, something like Illinois. And maybe as part of those single-page summaries, one, I think that would allow us to, again, start comparing apples to apples, as I've discussed. But two, if it looked at the governance structures of those organizations, the functions, this function question I think is important, the funding, and then some clarification as to the size of the regulated membership for those organizations. I think that might be helpful for, at least for me, I won't speak for anybody else, but at least as I'm thinking about what might be the ideal structure and what is constitutionally permissible, I think it might be helpful to look at the different models that are out there and have a ready resource that we could refer to. And maybe something I think that is important, something that would potentially define some of these terms, because we've been reminded that these words really matter and that we could be inadvertently talking past each other just by imprecise use of language. So that's something that I would propose for our consideration.
Okay. Other thoughts, Fred?
I agree with Hunter. It might be useful to look at the other models, but I think we have to remember, I think we're leaders in the country. And if we look at what other people have been doing, including Nebraska, I don't think we necessarily move forward or continue to do the great things we've done. We haven't always been perfect, and we've never been perfect in what we've done in connection with access to justice, inclusiveness, or protecting the public. But we've tried to do all those things. And, looking at a Nebraska model, I think the word of the day has been robust. We've been robust in these things, where Nebraska hasn't been robust and may not have even attacked those things. So I'd like us to keep in mind what it is we want to strive to do, and then look at those constitutional models and see if we can do it. Again, Hunter, I think looking at what other people have done, maybe somebody's done it better than we have, but a lot of them haven't. And, I really appreciate the scholars that we've had early on that have discussed the Supreme Court cases and other things. And I'm thinking, looking at those things, we figure out where we want to go. Can we go there? I'm becoming a little bit more optimistic that we can. And I'll share that later, but in my reading of the Supreme Court cases and what's going on, I don't view it as being defensive. It's like, let's make a structure that allows us to continue to do what we've done well and do it better.
One thing, too, calling myself, I'll come back to Hunter, I think, is that a hand up? No, okay, I won't come back to Hunter yet. Let's see if I can find my train of thought again. Is all these other structures have not withstood the test yet. So they're all doing similar to what we're doing, is looking at what they have and then looking at the tea leaves and looking at the cases and doing things that make sense for their states based on their histories and their current structures. And so while I think it is important, and I think having a handful to look at, so we just make sure we're kind of checking all the boxes in our head of the things we should be considering, is valuable. But I really take to heart Fred's comments of, this is really an opportunity for us, and we've gathered this group together to really think about it and think about what we can, sort of, if we could, what would we do? And I think we have so many wonderful resources in the state, in our bar staff, in our volunteers, in our Supreme Court appointed boards, in our sections, in our committees. And how do we do something that, while figuring out regulatory and voluntary, or how that might break out, but also how do we maintain the value that has really made us a leader in so many areas. So I think perhaps some sort of a little bit of a hybrid, spending a little time sort of through analyzing other states to make sure we're thinking, although I think you probably just did it, governance, functions, funding, size of the bar, current programs, what makes us special and not special. I think Mark's comment about what's happening in Texas shows you where different people think where the weaknesses are, and that, of course, is, we've always recognized that is a place that would be subject to scrutiny. Mark?
Well, in the Texas case, and I can send you the summary judgment motion if you haven't read it, but it's interesting because they also take on the legislative program and the lobbying program. And, if you look at the handout that the WSBA provided us with, where it shows, that I think it was last meeting, where it's got that nice multiple colored thing where you've got the mandatory to the permissive end. We have, on the permissive end, is the court rules committee. And that is critically important, and so it's one of our permissive activities, and I think it would be considered that. But there has to be an effective conduit to get the court rules shepherded on their way to the Supreme Court, and that characterizing that as permissive is difficult. But they are they're taking on the State Bar Convention. They're taking on the legislative program because it lobbies for things for certain groups. They're taking on, Texas has a $65 annual fee, legal service fee, that goes, I think, half to civil legal aid, half to public defense. It's mandatory. They're taking that on. So they're really, as these cases are developing, the folks that are seeking to, I'm not trying to characterize this in a pejorative fashion, but to deregulate or unregulate the bar, they're really starting to focus more laser-like on certain areas. And so the commonality, so that's eventually, when it does get to the U.S. Supreme Court, I think all those issues and programs will be on the table. I don't know whether the court will go one by one through them or whether there'll be some, broad amorphous rule that gives little or no guidance. But that's the briefing is getting better and more focused, I think, on that side of the case.
And we may end up seeing that in Washington too. As you know, we have a number of cases where this is sort of alluded to or sort of in passing. And to date, we have been successful in those cases being dismissed. But as they become more sophisticated and have more things upon which to rely that bring them in, it could become more. The case actually was in which I'm sure is partially why you have it, is one of the links in your reading materials for today. So at the top of the agenda, when more briefs are filed, we will make them available as they become available, as we find them. Eileen, I think I have you next.
Well, I guess being a public defender, one is congenitally oppositional. 2 points. The first is
so funny.
whether or not Keller survives. I mean, we've all read these cases.
Right.
We could all come up with a lot of different rulings. I think it would be very important for us to understand, and I talked to Tara before, what the functions are that the bar is doing now and what people they have there, what money is going there, because it would not be surprising if the bar or whatever entity is recommended doesn't have to justify the work it's doing and how it fits within whatever the Supreme Court does. The second point that I'd make is I've read all the comments that were posted, and there were a fair number of them. And I think, this would not be my preference, but people took the time to write fairly thoughtfully about the fact that they would like to see a very narrow bar, and that those functions should be strictly limited. So I'm not going to offer an opinion on that, but I do think we need to recognize that that is in the bar, and it in some ways is a legitimate, not in some, it's a legitimate point of view. So, but I really would like to have the function stuff, if it doesn't involve turning the bar upside down to get it done. Maybe I can talk to Tara or whoever would be most appropriate after the meeting about how to do that.
Why don't you and Dory do that together?
Okay, great.
So Dory can sort of shepherd it, since she's sort of the point person from the work group area, and be sure we're all on the same page. Okay, other comments? Yes, Esperanza, please.
In the spirit of some of the comments that have been made, great comments about our state kind of being ahead of the curve and have done some things that maybe other states have not. And the conversation around diversity and inclusion and the conversation around protecting the public, I think that what the bar needs to consider is that where is the public represented in that whole process? And by having representation of the public in that process, we will address the issue of diversity and inclusion. And to the extent that Washington State has done some of that, I think that's why we're ahead of the curve. That's what brings us to a place where we have a Minority and Justice Commission, and we have all these other commissions, and we have all these different committees in the bar, is because of the diversity and inclusion that has kind of been pushed, underneath and little by little, and then push back and then push forward. And so we have the opportunity to lead again and to be a bar that has something that says that this is part of the mandatory. Not something that's on the other side. It starts to feel like special ed or music programs in the public school system. I'm not special ed. I'm not a music program. I'm not an addendum to the education, and people like me aren't. And so it's an incredible opportunity for us here. And not to be afraid of that and figure out how do we do that in a way that is doable. You know, what do we want to strive to do is a question that was asked. And how have we gained where we're at right now? And I would say it's because of the small level of diversity and inclusion that Washington State has put into the work already. And can you imagine how much more we could do if we broaden that more? So I think we can do a lot more.
And my comments about how we're a leader and ahead does not mean there isn't always more to do. And that while we're ahead, it only means others may be very far behind. And so don't take my earlier comments as a sense that, oh, well, like we're there. We're so not there. And there are efforts being done in so many different communities, access to justice, the Minority and Justice, the BARS Diversity Committee, loads of work is being done in lots of areas, but that's because there is loads of work to do in all those areas. So, other comments, thoughts? Anyone in the seated in the room with us, having heard the discussion, have something, please come to the microphone. And if you'd identify yourself, I think that's Kay. Heidi Kay.
I'm Heidi K. Walter, and I just, as we were speaking and as Governor Stevens spoke by phone, a couple issues were raised that I'd like to bring in question to the task force here. And one is the role of legislative participation. I think this last session did show us with the bill by Representative Stokesbury that the legislature does have some strong opinions, maybe just a few members, but maybe it's important for both this task force to be educating and also maybe hear from them in a future agenda item that we hear maybe from the chairs of the judiciary committees and Representative Stokesbury, because he obviously has some pretty strong feelings on this. And secondly, with the idea of some additional requirements to practice, this mandatory malpractice, for example, but there's also, some of this LLT and other information. I think it would be something for making sure that this group also considers kind of where that would all fit into the new bar structure.
Thank you, Heidi Kay. Any questions for Heidi Kay?
Thank you.
Thank you. I think those are very good points, and I think because the State Bar Act was not, or the House Bill, Engrossed Substitute House Bill 1588, I believe, was not passed, the State Bar Act continues on the legislative books, and I think as it was being revised during session, it was recognizing, as Paula pointed out, certain aspects do need to be kept. The practice of law definition and the ability to incorporate and sue and be sued and be an entity. Then the question becomes, does the Supreme Court want the legislature to have more or less? And would the Supreme Court, would we as a work group be making recommendations to the Supreme Court and or to the legislature as to what they should do or not do going forward? I think the sentiment this year was a recognition, at least by the two chairs, Representative Lori Jenkins and Senator Jamie Peterson, that the court really had taken over this through case law, that we had the plenary authority, we've claimed it, we own it, we keep saying it over and over again. Having said that, there are a couple aspects that still have to continue. Representative Stokesbury, with his bill, which was the one that was sort of then adapted, amended by Representative Jenkins and Senator Peterson, was much more, I just don't want to pay very many bar dues. And I and my buddies don't want to, and was really a strip down that on first look looked pretty good, and then on later look was like, oh my gosh, that's doing a lot more things than you might read on a casual reading. And so I think there was his position that then became the later position, and then Senator Patton came in with his, at the end, striker language about electing, if it continued, how you would elect. And so we had a lot of things going on, and given that it did not pass, there's every reason to think something might come up next time, or we might want something to come up, again, trying to be more in the driver's seat and less in the reaction seat. So I think that is something for us to, as we go along and get closer to making recommendations, that there'll be sort of implementation steps or strategic steps that would follow. So I think we have to get our hands around the bigger issue to begin with, but then there'll be little. And I mentioned in one of our earlier meetings, I could almost see, depending on what the Supreme Court actually, if they accept any of the recommendations or make any change, that there might be we might come back together, if people are willing, for an implementation, sort of what are the next steps. So often you have the beginning, and then once it becomes a reality, there's more details. And we might have a different, depending on what the recommendation is, more bar involvement and participation than attending and speaking. So, thoughts? Dory, is that your hand up? That thumb? Okay, Dory.
In the event that it helps facilitate more conversation, I heard Mark say earlier, what were some principles kind of guiding your analysis? You spoke first to the legal constitutional structure being an important framing consideration, and only second to that, the public protection focus, and then finally, what's appropriate and good for the membership and the profession. It sounded very similar to what I heard Esperanza saying with respect to the focus on the public protection and the good of the membership. I'm wondering if there's just an endorsement that those are appropriate framing considerations for the work of the group.
Please, Andrea.
My inclination is to readily latch onto that idea, but I think that, like we've commented before, it's a matter of reaching a consensus around even what that phrase means. Because if I borrow from Esperanza, I'm going to infer that when she talks about protection of the public, that she is thinking that embraces the idea of diversity and inclusion, and it's not that addenda item, that it's already embedded within the fabric of that phrase itself. But I would imagine that that might not necessarily be the case or be the interpretation for others. And so I think that if there's a consensus around those things being linked and intricately related and connected, then yes.
Other thoughts or comments? Please, Mark.
But I think that's why the first component of the analytical process has to be, what is the U.S. Supreme Court going to let us do? And that's going to be the driver on whether we feel like diversity and those programs, our access to justice programs, are includable in our analysis or not. And they may, what I think what we're all hoping for is, when the U.S. Supreme Court does decide it, is clarity. So keep our fingers crossed. But yeah, that's I think we have to start there, and then I agree with you 100%. There may be some room for interpretation on what is permissible mandatory regulation versus enforced speech that they don't have to pay for. I really urge you to read this, and I didn't realize that this was included in the materials. Because I keep putting stuff together, but you really ought to read this summary judgment motion in the Texas case brought by the plaintiffs, because they are really starting to focus the arguments, and I think a lot of them whether it's this case or the Fleck case, they've got a court, I think, in Washington D.C. that's probably going to be pretty receptive to the characterization of many of these programs as enforced speech versus, part and parcel of a healthy regulatory process. And please take note, I use the word healthy, not robust.
So myself and then Eileen, I think it's important for us to consider and think about what the U.S. Supreme Court's going to do, and that's, of course, why we have anchored ourselves in the cases, and that's what prompting us to do it. But I really take to heart what I believe Fred said, which is, what do we want to be? And I would prefer us to, like, go, if it's our consensus, to go for the gusto. And if we think, as I do, that those should be included, we should figure out how we can support it when the royal we, not me as chief, but the royal we, how we would support it if we were challenged as to why that would be part of being a lawyer in Washington, a licensed professional in Washington. And if we lose, then we are disappointed. If we ultimately lose, the U.S. Supreme Court or the U.S. Supreme Court rules against what we decide is what we believe is the robust, appropriate thing going into the future for the practice of law and licensed professionals in Washington, which is the practice of law. So I'm trying to be inclusive, but I'm working on all my terms too. That then we're really disappointed, and we have to change because the U.S. Supreme Court has told us to change. But I do not want us to limit ourselves initially until that time, because I think this bar and this Supreme Court have historically, given all the groups and things we've talked about, felt this was really important. And so I would like, to the extent we agree and can define our terms and see what's in and what's out, that we would go forward with that idea. And so I think it might be a little too early to do Dory's, do we accept that concept? But I think next meeting we could come back with those concepts as identified, try to give them meaning that we could then play around with, and then if we had consensus, then we could start those building blocks, because I think those values are really important for that first step, because I think it'll guide a variety of questions, and we can refine them. They would just be what we'd start with, because then we might say, oh, well, that's a little different, or this changes that, or what we're doing. I don't want us to get too detailed too soon, but I do want us to start having sort of some big concepts that we feel we're reaching some consensus on, and also so that then the public and the lawyers and others who are paying attention, which many people are, surprisingly to me, a lot of people are paying attention and engaged. I shouldn't say surprising to me, I just know sort of like comments. Years later, you find out people, oh, you were bar president? Oh, for a whole year? Wow. This is clueless. You have a column every week, every month, et cetera. That they can then start giving us feedback as if their reactions. I have Eileen and then I have Fred. Do I have any other hands up yet? No. Okay, Eileen, please.
Well, I'm a little more conservative than some of our speakers. And I'm also probably parochial enough to wish that we could solve this on our own or work it out for ourselves. But if you look at the people who are bringing these lawsuits, the Goldwater Institute and Jones Day, I think you can expect that if we were to, that no matter how we do it, there will be a challenge to diversity and inclusion, et cetera, as an ongoing part of the Bar Association. And here, and also public defense, which, of course, is no surprise, my particular place that I would like to see protected. So I am concerned because Janice is pretty clear about speech, and the bar, I guess the question is, if we go forward, because the Board of Governors has in the past taken positions that are speech, that the court has spoken to them about, I think there needs to be some acknowledgement of that in what we recommend going forward and in how pure political speech can't be part of the Bar Association. That's my reading of Janice. Others may disagree, but I think there needs to be an effort to say there's going to be a break here between some of the past actions and what the bar does going forward. And in terms of a broader reach for the bar beyond what I think people have called the strictly regulatory, the discipline, the admission, that, again, the functions that the bar takes in the name of those actions need to be very clearly described. And that way, we can try and make our best decision, and then you live with the consequences. It may not be the right decision. It may not be one the Supreme Court upholds ultimately, the U.S. Supreme Court. But that is how I would like to approach this. And I need a little more information. And I'm not sure that we necessarily, that if we focus on the functions and don't use the labels, if you will, then we have a more defensible position for whatever we are choosing to do. So that's my thoughts on the approach and the next steps to take.
Thank you. Fred?
We've talked about, or members of the work group have talked about, our aspirations and what limitations we might have in the law. But the two things go together. You can read these Supreme Court cases and figure out there's some things we have to do in order to do what we want to do. It's clear on the free speech cases, we need to remain vigilant about how we police what the organization can do and what it can't do. And there's some rules. And just making sure that we have mechanisms in place, and there's been mechanisms in place, continuing those mechanisms and making it strong. And with respect to the antitrust litigation, there's some things, the composition of the board and who the board answers to can make a big difference. We can maybe do what we want to do, but we might have to make a few changes in the structure. And so, Mary, I'd say I agree with both you and Mark. I'm not trying to be, kumbaya here and bring us all together, but we look at both of those things. We figure out what we want to do, and we look at the structure so we can do it, so that it can pass constitutional muster. And I also agree with Eileen in that we can't read all the tea leaves, and the organization is probably going to get sued, but we make educated, lawyerly business judgments.
Thank you. Other comments, questions, suggestions? Anyone in the room? Anyone online? More discussion that you'd like to have now about this? Anyone who has, yes, Mark and then Eileen.
I apologize. I've spoken too much today, but
It's not possible, Mark.
thank you. I think we have to. I think imagine yourself before the United States Supreme Court. Okay, Counselor, why should lawyers in Washington State pay for access to justice? Why should lawyers in Washington State pay for diversity and inclusion programs? Why should lawyers in Washington State pay for lawyer assistance programs? Those are the questions we have to look at and answer, and you probably know where my sentiments lie on those things as a member of the board of the Legal Foundation of Washington for many years and so forth. But those are the questions. What does that have to do with justice? What does that have to do with lawyer regulation, Counselor? Because those are the questions that are going to be asked. And so we need to be prepared to, if we're going to support these programs and we're going to ask our members to pay for them, we have to have it has to be grounded in what makes what protects the public, what ensures a better and legal profession, a more capable and ethical legal profession. So just picture yourself before the court. You can take take a position on either side of the issue, but that's what it's ultimately going to come down to with those. Even a legislative program. Counselor, why should Washington State lawyers pay for the Washington State Bar Association to lobby for legislation in favor of LGBT rights? And that's what the Texas case is taking on. Those are the questions we're going to have to answer.
I have Eileen and then Andrea.
Oh, I just wanted to follow up and confirm, because the antitrust issue is not clear to me. I mean, well, a lot of this isn't clear, but I think some of that I'll put on the court. But the antitrust issue, so next time we will have someone who will speak on that? Is that correct?
Yes, who is not available until next time.
Okay, all right, that's all. Thank you.
So Mr. Jeffrey Green, who is a regulator at the Federal Trade Commission, and who, it's my understanding, argued the case, the North Carolina case, will join us remotely, and he'll have a presentation for us as well as take questions.
Andrea.
Thank you. I'm just reminded of something that Paula said when she was presenting to us. And it was a phrase that I wrote down because I took it to heart, that a credible entity has to address issues of diversity and inclusion. And I think that we could go on and on about debating about how those things relate to or how we would defend that. But I think it gets back to the initial question of like, well, what do we believe to be the basic competency and qualifications that a lawyer should have? And we have to be able and willing to draw a nexus between that, those competency qualifications and our value of the people that we represent, our value of the community. And so I think that that's part, and maybe that's part of the conversation and the research that we're putting together as we look at those numbers. Eileen keeps commenting about that she's she's a defense attorney, or, right?
Public defender.
A public defender, right? And so that's a great example because I'm sorry, our system, we know that is disproportionately represented by people. We have a disproportionate number of people of color who are incarcerated. We have an underrepresentation of minority lawyers in general. So how is that not intricate related to what type of priority we want to place on representation? When we look at our court system and an individual is accessing our system on a daily basis, they are confounded with the reality of just the lack of individuals who see and reflect them and who understand the things that happen in their community, can just have some human compassion. And so the idea that we're going to talk about protecting the public, but at the same time not have a real, genuine conversation about the public not being at the table, I mean, that it baffles me. And that we're going to have a conversation about having a bar association or having any sort of bar and say, okay, but we're going to regulate people who look like me to the periphery. That's unimaginable. I don't think that we can do that in a way that fully meets what anything that I think we're chartered to do when we're looking at our bar. And so I think that moving forward, that has to be an integral part of that conversation. And in terms of responding to that question, what type of lawyers, what type of lawyer competency and qualifications are we looking for, that has to be a part of it. And I think we start with the numbers, we start with the stats, we look at our community, we look at who we represent, we look at how those individuals are impacted by the lack of presence and representation in various areas. So we go to the facts, we pull out the numbers, and that's how we begin to answer the question of the value of diversity and inclusion in competent lawyers.
Thank you. Andrea has spoken. Does anyone else on the work group have any comments or suggestions? Yes, Esperanza.
One word, ditto.
Ditto for Esperanza. Jane, I want to be sure, since I can't see your hand, if you had anything you wanted to add.
Thank you for asking. No, it's been very educating to me to be able to listen to all these comments, and I kind of have to go along with just about everybody saying, it appears we need to have a lot of discussion. It also appears like there's going to be a lot of controversy, but at the bottom line, I fully support that we need to be able to answer those really hard questions when we develop our recommendations. And we need to be able to have coherent, simplistic, I think, answers to those questions so that everyone will understand what we're recommending and where we're coming from.
Like I like to say, clear and direct.
Right.
Fred, you mentioned earlier you actually had some thoughts and suggestions. Did you want to share those today, or did you want to wait until a later meeting?
Yeah, I'll send it to you and Dory. I guess I'm just sort of a legal junkie on some of this stuff, and so I went through and read, and in keeping with what you've got on the agenda next time, I went through with one of my law clerks on the antitrust issues and put together that piece, and I think it's one we can tackle. I think that what was happening in North Carolina was so different than anything that we've tried to do, that we do a few things and we're going to be able to get by the antitrust one. The tougher one is what Mark has talked about, and that's going to be the free speech one. We're going to be challenged there, and we know some things we have to do, and we should continue to do those, and we should point out that our organization is doing those things, and maybe we should renew how we look at those things and how strictly we look at it. But we're going to get challenged on those. I don't feel quite so much concern about the antitrust, and I'll share that memo. I'll send it to Mary and Dory. Let me tweak it a few things, make sure that I haven't ended any of my sentences with a preposition.
My pet peeve.
Okay, is that you? Okay,
One of many.
Okay, well, I'm sure I will hit some of your other peeves, but
Teasing.
But we'll put it together, and I'll get it out hopefully this week.
Great, thank you. Yes, Hunter.
Thank you again. Just a brief comment as we continue thinking about our priorities and the analytical framework that we're going to use as we tackle this question of what is constitutionally appropriate, what is the ideal bar structure for our state at this time. One of the things that we haven't really talked a lot about yet, and I think it's actually a pretty good sign, because maybe we're all kind of assuming similar facts here, or similar values with this, but is the question of whatever we recommend, how will that impact particularly the disciplinary functions of the state bar? And I've been focusing in on that and thinking about that because I do think of it, and this is not in any way to minimize any of the other things that the state bar does, but I think of it as kind of the crown jewel of our regulatory functions. I think it's so crucial to maintaining the trust of the public for this in this organization and in this profession. So that's one of the many things that I'm thinking about as we begin looking toward our recommendations to the court, is how will our recommendations impact the disciplinary system.
Great. Others? Yes, please. Mr. Watley.
I just wanted to echo those same sentiments, because it's the disciplinary system that is the first line of defense to protect the public, all right? And the second line of defense is you people before me today, and I just wanted to thank you again for your time and your leadership and your volunteerism and hearing for all the diverse opinions of how to move forward on this. It is vastly complicated, it is hard, it is nuanced, and it's a great burden, but I just want to thank you again for listening to absolutely everybody here today, listening to myself, and to be able to thoughtfully, proactively look at what's in the best institutional changes to affect not only the membership, but the public at large. So thank you for your leadership, Ms. Fairhurst. I really genuinely appreciate it.
Thank you. Thank you for attending, your mother attending to support you. All right. I have a hand back there. Please, yes, of course. Nancy Hawkins.
There was a question earlier, and I think we've pretty much answered it, about whether we should do nothing. And I don't see any hands raised that we should do nothing, and that's great. And I'm back there thinking I'm a couple weeks away from a trial, and a lot of what we're really doing is what good lawyers do for trial. We don't just not show up and say, well, do whatever. And we don't show up and kind of put on some testimony and then say, okay, write whatever you want. We come in with proposed orders, and if we're smart about it, those proposed orders make it really easy on the judge. They say the findings of fact, they say the conclusions of law, and then they say what the rest of the ruling should be. And that's really what this group is doing, or needs to do, is we have to come up with, first, what are all the issues? Why do we want those issues either part of the Bar Association or not? What do we want to have happen? What structure should exist for it, et cetera, et cetera? And we have to think of all the details. You have to think of all the details. We obviously have to help you do that to the extent that we can. But I'm really struck, too, that there's this unity of belief that certain issues are important and must be there. Diversity, access to justice, all that. And our minds say, well, of course, they should. And they should. But you read these positions from other states and you think, oh my God, or even in our own state with Keller appeals and that sort of thing. What's wrong with all these other people that don't share our opinion? They're misguided, they're not smart, they're whatever. But we have to also accept that there's that point of view out there, and we have to address that too. Because we can't just assume that the U.S. Supreme Court's going to agree that we should have more attorneys of color, that we should address the issues of access to justice. We have to convince them that those issues are important. And so let's not skip that step, even though we apparently collectively agree that that's important. Let's not forget we have to convince people. And someone brought up, maybe Hugh brought it up last time or a couple times ago, that the U.S. Supreme Court comes from other states, and their points of view are sometimes reflected by those other states and what people believe in those states. And we're pretty liberal in this state by those comparisons. So let's keep those issues in mind. And I wonder if we can make an argument sometimes, when I was hearing about all the issues being addressed in Texas, that taking a position against lesbian gay issues, against access to justice issues, is by itself political speech, and thereby justifying political speech on the other side, or differing speech on the other side. Anyway, things to think about. As always, Justice Fairhurst, a wonderful job chairing, although 3 minutes late. But
It started on time without me, I just want you to know.
I know, I wrote
I
that
called,
in my
I said,
notes.
Dory, start the meeting. I'm coming. Thank you, Nancy, for your comments, and thank you for the compliment. We are now at 11:55. This is the time when we identify future agenda items. I think I'll have Dory say what she has on her list already, and then if we're missing something, which of course Dory doesn't know, I just was going to do that to her. So Dory.
So we've talked a couple times now about that the number of presenters coming before the group is diminishing. We do have on deck Mr. Jeffrey Green from the FTC for next time. But I foresee that the group will need an opportunity to talk and debate and challenge one another with different ideas. And some of what you've heard discussed here is, well, if there are things that we have a mind about, how can we reconcile them and prepare ultimately to defend the choices that we as a state make? And then ultimately distill them to written recommendations for the court. As we're transitioning to that phase of the work group work, I expect that the agenda will have a lot more time for debate and discussion among work group members. I can share, of course, the resources that inform that discussion. I can bring forth that final antitrust presenter, but that's as I'm anticipating your next meeting will look, with a lot of discussion to frame how we go forward.
What I think we should have, if it's available, in addition to that, the thought was really the first 3 meetings was going to be informational, and starting with the 4th meeting, we're scheduled for 6. We have 2 optionals that we have sort of in our back pocket. I'm really hoping we can really move forward and try to shoot for 6. Would be the functions, to the extent we can identify those, looking at least 6 states, the one-pagers, to the extent my clerks can do a larger, sort of a big view of the 17. Part of it will be like digging deep, coming back with some of the terms. What do we mean? What do these terms mean to us? Trying to identify, some of that will come through with the functions. Thinking about, which we didn't really talk about too much today, but I think sort of just thinking conceptually, status quo, some sort of a, maybe Nebraska, where you have sort of one that's sort of the overall entity, but part of it goes as sort of a different lane. Maybe it's still here physically, but there's sort of 2 lanes under a bar that has the 2 pieces. Really a complete break-off, or some other sort of hybrid, and how that works. And then looking at, within that, sort of function, funding, governance, and so sort of like what's in and out and what's not. And then I think it, maybe not the next meeting, but the 5th or 6th meeting, as we refine that more, how does that work between court rule, legislation, bylaw changes to the bar, those types of things we would have to look at least based on the recommendation, sort of next steps. Please, Eileen.
Well, I just had one question based on what the woman from Nebraska said. Are there Washington statutes that say you must be an attorney to do something? I mean, aside from being a lawyer, I'm not aware of any, but
we could do a law clerk could do an easy search to sort that out. So, but I think that's a good question. Not that comes to my mind, but I don't know. The bar might have more knowledge than I do. Doug, do you have a knowledge? Please come to the mic. Doug, go to the mic, please. Or you tell us later. If you could let us. Doug, one came to Doug's mind. If anyone comes to anyone else's mind, but so yeah. But you must wait till next meeting to find out a reason to come back again. All right, I have 1 more minute. Is there anything I didn't sort of capture from our conversation that you would like us to try to at least see what we can have for the next meeting? So the expectation is our speaker is going to speak how long? Mr. Green? And do you know how much time he has?
I'm still working
You're
that
negotiating?
out with him, yeah.
So it'll be no more than an hour. It probably will be somewhere between a half hour and an hour, I expect. He does have a presentation and he will have comments, which means that we will have 2 hours for really starting to discuss. So I want you to be sure you've read all your materials that we've sent you, that you have read all the comments that people have posted, that you've read our notes, which are very just sort of capturing it, but I approve them, and be ready to come back and have your own lists of things you think we as a group need to talk about. So bring your own list back of what you think, individually, what you think we need to do. We'll compare those, kind of come up with a master and start working our way through. Okay, people comfortable with that? I have noon, and I am going to, unless there's anything for the good of the order, Dory?
Just one note. Thanks to the great staff work being done here at WSBA, any comments this group is receiving continue to be posted up. So do check back as work group members to see an ever-expanding list of public comments in the same place.
I want to thank you all for attending, work group members, people in the audience, and special thanks to Rex Nolte and Clay Peters again for providing our excellent audiovisual and technical support. Thank you. Our next meeting is on May 29th. And it'll be the afternoon meeting because we alternate. So 1 to 4 on May 29th. Thank you. And we are adjourned.